wait, Your Honor, I don't have screenshots.
You will not interrupt, ever. I let you go on and on. I told you what I'm trying to focus on here. Keep trying it, Mr. Vincent. You're going to run into trouble with me real fast. That's a wrong answer. I'll deal with this in a minute because right now I'm furious, Mr. Vincent, that you would represent that client defendant's remanded.
One of the most bizarre court cases I've ever witnessed occurs when Judge Simpson lashes out at this cocky lawyer for failing to tell his client to turn himself in despite the fact that he was legally required to do so. This guy simply disregarded a judge's order, assuming no one would notice, and then waiting to hear Judge Simpson's final remarks. This is truly crazy. Was this a careless error or some shady courtroom scheme? As we watch, please share your thoughts in the comments section. Let's get started.
Court calls case People versus Cameron Carter.
Well, Your Honor, John Vincent on behalf of the defendant who stands to my right.
All right.
Say your name. Come on, Carter.
All right. We're going to deal with the bond hearing first and then decide if we're going to go with this case. Mr. Vincent.
Well, Your Honor, is the witness here? Because that is all. I mean, all the allegations are based on her words. There's been no police contact, no video, no third-party witness, no DNA, no fingerprints, no police contact with my defendant here.
So he wants a hearing on this bond violation?
None of these phone numbers connect to his account. He absolutely denied the allegations in here. There is no physical evidence, and if there is not a witness here, Your Honor, then both the underlying case should be dismissed and this alleged...
I'm not even talking about the underlying case. So just deal with what I told you to deal with.
All right, well,
does he want a hearing on the bond violation?
Absolutely, Your Honor.
When are you going to have the other report?
I'm not sure, but I can check on that today. And I'm also waiting for the actual screenshots of the text messages that are written in the Romulus police report. And if he's saying that that's not his phone number, I can also get a search warrant as to that effect.
In that police report, there are 6 phone numbers listed. The police report indicates that none of those numbers are Mr. Carter's. If there are screenshots, I have not received those screenshots. It's the first time I'm hearing that there are 2 other potential police reports out there. However, this police report says that 2 officers showed up. I don't know how a Wayne County Sheriff's Department police report would be any different than this, as far as I can see, there were no Wayne County sheriffs on the scene of this alleged incident. There's just simply no physical evidence. There's no third-party evidence. And frankly, if you read through the report...
I did. Before I revoked your client's bond.
Yeah, okay, well, I would hope you did. When you start to read through it, the allegations in there, either it's a lie or he's the luckiest guy on the planet, because I would think that the Romulus PD would be able to get over there in the length of time that all of this stuff is alleged to have happened and find a purple Taurus. She says at 1 p.m., he began to call her, and it somehow got into an apartment, beat on the door of the apartment, left the apartment, started yelling through the window, and generated somehow, all while outside, 6 other phone calls from 6 different numbers, none of which line up to the defendant. If she's not here, Your Honor, then I think that is a very, very strong indication that this is not factual. The other thing in this, Your Honor, this person alleges that he stole a gun from her in Pittsfield Township. Yeah. Well, if that's the case, then shouldn't this have been a little higher priority? I think the prosecution knows that this is not accurate. There's nothing before the court today to indicate that he is guilty of what they're saying he's guilty of. If she's not here, she should have been here. There's no Romulus police officers here, not that they saw anything anyway. There's no third party in the police report. It says witnesses, none. Wait a minute. He's broke into this apartment complex, banging on the door, goes outside, supposedly shouting the N-word. Don't you think somebody would have witnessed that, especially at 2 p.m.? without a witness, without some shred of physical evidence. There's nothing. This is just the allegations of someone who did not bother, apparently, to show up to court, both for this and presumably for the underlying charge.
Okay, what he's saying might sound good for now, but just wait until the prosecutor steps in and starts picking apart those over-the-top claims. It's obvious the defense attorney is bluffing, and bluffing hard. Sure, it's his job to defend his client, but the way he came in like he runs the place? No, he's giving off that smug, performative vibe, like he's more interested in camera angles than legal arguments. And let's not gloss over why we're here. His client isn't in court over something petty. He's facing serious charges for abusing his girlfriend. And this isn't his first run-in with the law. This isn't some misunderstanding. It's a pattern of behavior. Also, attorneys are supposed to show candor toward the court, but judging by his tone, that rule didn't make it into his playbook. Let's see how long the act lasts once the prosecutor brings out the actual evidence and puts an end to the show.
First thing, this defendant is on bond awaiting this final settlement conference where he's charged with domestic violence. He's also on bond awaiting pretrial where he's charged with child abuse sport. He's also on bond awaiting a probable cause conference where he's charged with resisting and obstructing a police officer and fleeing third degree. Mr. Vincent claims that he knew nothing about screenshots, so I just said on the record I don't have them, I'm awaiting them. But they are in the Romulus police report. They say that they do have screenshots, so maybe he didn't read that report. Also,
Oh, wait, Your Honor, I don't have
excuse
screenshots.
me,
You will not interrupt, ever. I let you go on and on. I told you what I'm trying to focus on here. Keep trying it, Mr. Vincent. You're going to run into trouble with me real fast. Ms. Kirby, you may continue.
Thank you. I also explained in my motion that the Romulus police report is different than the two other contacts that this victim had with the sheriff's department. I have included those police numbers. Those are also in the motion. So I'm not sure what he means on, I have no idea why the sheriff's department and Romulus were here. No, it's completely different. And I don't have the accusations in those. I'm awaiting to get those, given that they're not in our county, and I followed the process to get those. Also, this is, if we're having a bond violation hearing, I would just remind the defense counsel that it's not beyond a reasonable doubt for a bond violation. So I would ask the court to take what it has in front of it, including the Romulus PD report, and either adjourn so I can get the other police reports, and so I can get the actual screenshots and possibly a search warrant for this. And I would ask for the defendant's bond to be revoked. And he to be remanded. Given the seriousness of this case and the seriousness of his other two cases, I do believe he's not only a threat to the victim, but to the safety of the community and also children. He seems to find it funny as his defense attorney speaks, which also tells me that he does not take this serious at all, which also concerns me. As for the complaining witness not being present, I did not know that he was going to be here. I thought he was still out since he had not turned himself in, and his attorney was well aware that he had a warrant out with no bond. So she is not present. Last time I spoke to her, she was in fear for her life. She said she would continue to answer the phone, but she has been placed in a different place that I know of the location that she does not want me to share out loud. I have no problem sharing that with the court. But she is not present, and regardless if she was present or not, I can still proceed based on forfeiture by wrongdoing with the interference that the defendant has committed himself through these other police reports. And I was going to ask for time to get those anyway so that I could present those at trial. So regardless if she is here or not, and just for the record, the court rule does not actually say I have to have a witness present. It actually says I have to say if I can proceed or not, which is what I'm doing. Thank you.
Anything else, Mr. Vincent?
And if hearsay, allegations, someone's not here. This all happened in the last 48 hours, 72 hours.
Two things is not here, but if I look at what's in here, that first of all, you're mixing two things. Because certainly they can proceed by hearsay as regards to bond violation. So that maybe we can clear that part up, because so they don't need her here for that. As to the final settlement conference, the people have stated to the court that they can proceed without her, if necessary, but that they also do know where she is.
I don't know how they could possibly proceed when there is not a
That's
stitch.
not your issue. They've made the representation to the court.
Okay, and I'm making a representation to the court that when you read the police report, which you have,
I read it.
then you know that there is only her allegation. At least for what I have in front of me and what you have in front of you. And he is here. He's availed himself to the court every time that I've had anything to do with him.
Why didn't he turn himself in between the time I revoked his bond and today?
Here's where things take a serious turn. The defendant had just been out on bond a few days before this hearing, and the judge didn't mince words. He gave the defense attorney a direct order. Have your client turn himself in. No gray area, no wiggle room. It was crystal clear. But then, total chaos. The defense attorney never told him. Just didn't pass it on. Like maybe he thought the judge wouldn't notice, or that court orders were more like guidelines. That's not just careless. It's dangerously close to sabotage. And yeah, that kind of silence isn't just a bad look. Under Rule 1, 4 of the ABA, attorneys have a duty to communicate with their clients. It's basically lawyering 101. Ignoring that can land you in serious misconduct territory. Honestly, the whole thing feels unreal, like something ripped from a legal drama. And you could see it on Judge Simpson's face. That slow, simmering frustration. It was only a matter of time before it boiled over.
Because you, as an officer of the court, should have instructed your client to do that the court had revoked his bond. So I want an answer to that question.
Yeah, I mean, we were going to be here today.
That's not an answer to my question. Mr. Allen.
According to what the defendant just told his attorney is that he told him to just show up today and not turn himself in.
That's correct, Your Honor. I mean, and that if
Oh, put me in handcuffs, man.
That's a wrong answer.
I'm sorry. I mean,
Way the wrong answer.
I'm sorry, man. I'm actually.
I'll deal with this in a minute, because right now I'm furious, Mr. Vincent, that you would represent that client. Defendant's remanded. Take him. Court's going to stand in recess. Court calls the case of the people versus Cameron Carter. Recall.
now Vincent, on behalf of the defendant. Yeah, there was absolutely a mix-up. And as much as my understanding was that he had spoken to the court, and they did not tell him to come in, and I should have come in. Yeah, absolutely a mistake on my part.
Well, it's not only a mistake, it's a sanctionable offense. And I think you ought to know that. To willfully tell a client, or even intimate to a client, that they should in some way disobey a court.
In no way, shape, or form, Your Honor, did I meant to have that effect happen. My understanding was that he had seen you in person this week, and that you come to court from. I would never, and I think you know that about me, I would never have anyone try to knowingly or disobey an order. I would never knowingly disobey any of your bond conditions or orders. He is, I mean, I don't know, Your Honor. This is a horrible mistake, and I'll fall on my sword for it. But it is a misunderstanding. It's not any. In no way, shape, or form was I trying to get him to avoid justice, and he certainly is trying to avoid justice on this, Your Honor. I understand that these charges and allegations are serious. I mean, all I can say, Your Honor, is that my understanding was that he had spoken to the court this week, and that he was free to come here Friday. We clearly had, at no point did I ever advise Mr. Carter to do anything else other than follow the law. And it must have told him that a dozen times, and that every time I've talked to him, do not violate your bond, don't violate your bond, show up Friday. That's when we have a court date. My understanding was that was the understanding. And it is absolutely a snafu on my part, and I beg the court's forgiveness.
Drop your thoughts in the comments, because I'm genuinely stuck on this one. I can't wrap my head around what this attorney was thinking by not telling his client to show up when there was literally a warrant out. Like, how is that not the first thing you mention? It had to be a mistake, right? Unless he really thought he was pulling off some galaxy brain move on a checkerboard. But based on how he's fumbling through his explanation right now, it's giving major middle schooler caught with a vape and blaming his non-existent twin brother energy. It's that unconvincing. And again, attorneys are legally required to keep their clients informed, especially about major stuff like, hey, you need to show up or you're getting arrested. That's not an optional memo. That's the basics. Instead, he's up there sweating bullets, trying to downplay this whole thing like it's no big deal, as if he's being questioned over missing snacks, not facing a potential bar complaint. This whole situation is wild.
He has an appointment today at 2 p.m. to see Washtenaw Community College counselor. He's trying to get his CDL so he can take care of his kids. He is working at another job. He's availed himself to court today, Your Honor. If this is bound over to jury selection, he'll be there then, too. He understands this is serious, Your Honor. He's just vehement in his innocence, and I perhaps have been overzealous on my part. I meant no disrespect to you, court, to the people.
What I'm going to do in this case, because, I mean, something's got to be decided as to what was told this defendant. That may have to be resolved some other way, but the court will take whatever action it deems necessary, and I won't do that until June 26th, if I deem it appropriate to do so, because as angry as I am right now, I'm not going to make that decision on that. I will set a bond hearing in person in this case for June 26, 2023 at 9 a.m. All of the paperwork will be sent over, and we can deal with it at that point. In the interim, defendant's bond is revoked. I will adjourn the jury final settlement conference that we were going to have today, as well as the jury selection. Jury final settlement will be my next one, August 11th, 2023 at 9 a.m. Jury selection, August 14th, 2023 at 8:30. Defendant's remanded.
Yeah, my echo.
I don't think you want to do that right now. I am just.
Your Honor, you know I did not.
This might honestly be one of the worst mistakes I've seen an attorney make in a long time. And look, Judge Simpson seems like a pretty level-headed guy, so I doubt he's going to blow up this attorney's entire career over it. But I'm not even sure it was a mistake. The victim wasn't notified. The state wasn't prepared. And it kind of feels like the attorney tried to pull a fast one, hoping no one would catch it until it was too late. What do you think? Was this a genuine screw-up or a calculated move that almost slipped through? Either way, if your legal strategy starts looking like a deleted scene from Better Call Saul, it might be time to reassess. Attorneys have a duty to both their client and the court, and this guy might have just dropped the ball on both fronts. Let me know in the comments. Should the judge have come down harder? Or was he fair, given the situation? Thanks so much for watching. I post every single day, so stay tuned, and I'll see you in the next one.